So the Ninth Circuit just reversed a prior 2-way win coming out of the state of California and just sent the case back down to the district court to be completely reheard. So let's talk about this. But real quick before I jump into this video, if you agree that the Ninth Circuit needs to finally uphold the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they will need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website linked down below. And thank you again, SDI, for sponsoring this video. So like I said in the intro, the Ninth Circuit just issued an order reversing a prior decision of their own, which struck down California's ban on 18 to 20-year-olds from being able to purchase semi-automatic centerfire rifles like AR-15s and AKs. The case we'll be talking about in this video is Jones v. Bonta. In this case, the Ninth Circuit considered whether California is violating the Second Amendment by barring individuals 18 to 20 from being able to legally purchase rifles and semi-automatic centerfire rifles. The law in question is California Penal Code Section 27510 subsection A. This law in California states FFLs shall not sell, supply, deliver, or give possession or control of a firearm to any person who is under 21 years of age. There are some exceptions for people who are in the military or National Guard members, or those with a valid hunting license. However, even under this exemption, 18 to 20-year-olds cannot buy handguns or semi-automatic centerfire rifles. On review of this case, a lower court back in November 2020 denied the plaintiff's request for a preliminary injunction to stop California from enforcing this law and ban on 18 to 20-year-olds from being able to purchase these types of rifles. That denial was then appealed up to the Ninth Circuit. A 3-judge panel at the Ninth Circuit level reviewed the case and ruled that the district court did not abuse its discretion in declining to enjoin the requirement that young adults obtain a hunting license to purchase long guns. However, the Ninth Circuit also found in that same decision that the district court did actually issue an error or did engage in an error in not enjoining an almost total ban on the purchase of semi-automatic centerfire rifles like AR-15s and AKs. In the opinion, the panel stated, without the right to obtain arms, the right to keep and bear arms would be meaningless. For this reason, the right to keep and bear arms includes the right to purchase them, and thus, laws that burden the ability to purchase arms burden Second Amendment rights. Therefore, they framed the question that needed to be answered in this case, Jones v. Bonta, as based on a historical understanding of the scope of the Second Amendment right, whether the right of young adults to bear arms is conduct that is protected by the Second Amendment. So there, originally Jones v. Bonta, when looking at this aspect of the California law, they actually applied a historical approach. They also said that having concluded that the laws burden Second Amendment rights, we now consider the district court's choice of a tier of scrutiny and its application of that tier. The district court properly applied intermediate scrutiny, they said, to the long gun regulation, but should have applied strict scrutiny to the semi-automatic centerfire rifle ban that was also in place in the state of California. They stated that the long gun regulation allows a young adult to buy a long gun if he gets a hunting license. This requirement does not prevent young adults from having a firearm or from using them in any particular way. Because this regulation does not impose a significant burden on the Second Amendment, in that right to keep and bear arms, the district court properly applied intermediate scrutiny. So they're saying on that aspect of California law, the hunting license to purchase a long gun to be able to hunt, they said that that required intermediate scrutiny. And on analysis, they said intermediate scrutiny actually found that this aspect of the California law was valid. Now on the semi-automatic centerfire rifle aspect and restriction, the court stated strict scrutiny applies. The main difference between this ban and the long gun regulation is the exceptions. The long gun regulation has a readily available exception, at least on its face. Young adults can get hunting licenses. The semi-automatic rifle ban has no such exception. The only young adults who can buy semi-automatic rifles are some law enforcement officers and active duty military service members. It's one thing to say that young adults must take a course and purchase a hunting license before obtaining a certain rifle, but to say that they must become police officers or join the military service is no exception at all. In effect, this is a blanket ban for everyone except police officers and service members. So looking at the two aspects of the California law, the original 3-judge panel and the 3-judge panel's original ruling applied intermediate scrutiny when it came to long guns and the requirement that you get a hunting license, but they applied strict scrutiny when it came to the blanket ban on 18 to 20-year-olds from being able to purchase semi-automatic centerfire rifles. After that decision in Jones, the Supreme Court ruled in another really important landmark case, which is the New York State Rifle and Pistol Association v. Bruin case. One of the primary findings of that case was the finding in regards to tier-based scrutiny and the use of that type of analysis. And the Supreme Court essentially said there in Bruin that tier-based scrutiny balancing of interests should never be used in Second Amendment cases. In fact, the Supreme Court expressly rejected the use of intermediate scrutiny, like what was used in the Jones case on that first aspect of the California law. Another really important thing that the Supreme Court said in that Bruin decision was the type of analysis that should be used, which is text as informed by relevant history and tradition. So that is the standard for all these Second Amendment cases going forward. After that Supreme Court ruling, the California Attorney General requested a rehearing of the case in light of Bruin. Of course, this was simply a strategy to get another chance at the case and to essentially kind of moot or to get the original ruling of the three-judge panel vacated. But in reality, they knew that the Bruin text as informed by relevant history and tradition standard is not really going to be in the state's favor. But really, this is what they are wanting, is to stall these cases out for as long as possible, and especially to get a second chance at a case that they lost. In fact, historically, 18 to 20-year-olds in the acquisition and purchase and possession of common arms is more favorable and completely would eliminate the California law if you're using text as informed by history and tradition standard. But California was using the Bruin decision to get another crack at a case that they lost and to have the case sent back down to district court for a complete rehearing and a redo of all of this entire case. Really what they want to do is to stall these issues out for as long as possible. Well, we just got an order from the Ninth Circuit, and they sided with the state of California and vacated their prior decision in Jones and sent the case back down to district court for a rehearing in light of Bruin. The order reads, appellee's petition for panel rehearing is granted. The panel's opinion is vacated. The district court's order denying plaintiff's motion for a preliminary injunction is vacated, and the case is remanded to district court for further proceedings consistent with New York State Rifle and Pistol Association v. Bruin. So the Ninth Circuit has continued their trend of refusing to hear these Second Amendment cases at the Ninth Circuit level, and they are refusing to hear these in regards to the Supreme Court's guidance in Bruin, and instead they're continuing to send these cases back down to the district courts for them to be restarted all over again. If this is any indication about what might happen in some other Ninth Circuit Second Amendment cases that are still pending before the Ninth Circuit, like the Duncan v. Bonta California magazine ban case and the Rody v. Bonta ammo day case, those cases are likely also going to be sent back down to district court. It's already kind of being teed up, and a lot of other cases have been sent down back to their original district courts for complete rehearings in light of Bruin. Now, there are some district court judges like Judge Benitez who may try to streamline the rehearings of these cases, but still the fact is that these cases are being remanded back down to the district court level, and it's simply going to delay these cases out even longer. One slim light of good thing that kind of comes out of this case being sent back down to district court is the application of text as informed by history and tradition in that standard, mainly because the three-judge panel's original decision was still using intermediate scrutiny and was upholding the hunting license requirements and the licensing requirements under intermediate scrutiny. So maybe on review, the district court will just outright strike down this California law, the hunting license aspect of it, and also the semi-automatic ban aspect of it using text as informed by history and tradition, because before using intermediate scrutiny, tier-based scrutiny, the Ninth Circuit did uphold an aspect of this California law. So a favorable decision may lead to a finding that this entire law is unconstitutional, which is what we want. But in reality, what we really wanted was the Ninth Circuit to do their job and to actually hear this case in light of Bruin. So that's what's going on in the Jones v. Bonta California 18 to 20-year-old purchase case. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is built by armed scholars, and this nation will be maintained by armed scholars.